Hi, folks. Guess my head's a little high up, so I'll fix that a bit. Hi, Lana. Thank you for sharing. Hi, Dale. Hello, Amber. Nice to see you tonight. And Dolores. Very nice to see you. Okay. And hello again, Dolores from your YouTube perch. Carmen, you're on YouTube too. Hi, Lana. Hi, Joe and friends. And Carmen says hi to Dolores. Okay, well, a little sudden change here tonight. I expected to have a conversation with the indie left, independent left, which would have been a very, very interesting combination. But he had a sudden illness in his family. He had to postpone, and I had to put together another show rather quickly. That show is entitled Infrastructure Politics and Securing Voting Rights. And it's about, in part, the inside politics of what is going on, and also about the really dire situation which we face in order to win the battle for voting rights. If we don't win it, I don't see how our system can succeed in fighting the climate emergency. I just don't see it. Carmen says, yes, Joe, I'm weeding myself off. I'm glad you are. If you and a few others do that, I'll be able to wean myself off Facebook as well. That would be a big help. Okay, so first piece I want to go over tonight comes from the Prospect. And specifically, it's a piece by the editor of the Prospect, Dave Dayen. And the name of it is Infrastructure Summer, the Senate deadline that isn't one. He put this up just yesterday on July 21st. And there's Chuck Schumer arriving for a news conference after the Senate Democratic Policy Luncheon in the Capitol, July 20th, 2021, 2 days ago. Today, sometime after 2:30 p.m. Eastern, the Senate will move to vote to proceed on the legislative vehicle for the bipartisan infrastructure framework, which I've taken to calling Portman Cinema after its two leading negotiators. This vote will fail. Republicans have been very explicit that it will fail. They've said they haven't had enough time to strike a final deal, more than a month after announcing the initial deal and agreeing to it with the White House. Yet they also have said they expect to soldier on after the failure of that vote, resolve the differences on Portman Cinema by the weekend, and present it to Senate Majority Leader Chuck Schumer like nothing ever happened. And Schumer appears resigned to indulging that process. Given all this, what was the point of holding this test vote if it answered no questions and led to no changes in the fundamental dynamic? Seen from one angle, the Schumer gambit of calling a vote, while met with seething anger from Republicans, absolutely worked. Specifically, negotiations over the final pieces of Portman Cinema weren't going anywhere until Schumer called the vote and the bluff of the Republican senators. Schumer had lined up all the Democrats in the Gang of 10 before his announcement, presenting a united front to complete the outstanding issues. We're now on a path where senators are talking about wrapping up by next Monday. Does next Monday mean in just a couple of days? I sure hope so. That wasn't going to happen without a deadline, says Dave. Schumer also needed to get clarity on Portman Cinema before crafting the vehicle for the reconciliation package. Right now, that package stands at $3.5 trillion. But the expectation is that if Portman Cinema falls apart, new spending in that bill would be folded in, pushing the figure to $4.1 trillion. You have to make the headspace for that in the budget resolution. In other words, in the reconciliation bill, which instructs the reconciliation process with top-line numbers that set the limit for spending. If the Senate passed a $3.5 trillion budget resolution, they couldn't fold in the outstanding money from Portman Cinema. So its fate needs to be clear ahead of the budget vote, ahead of the reconciliation vote. So in other words, what Portman and Cinema were doing in all this bargaining and wasting time is they were holding up the reconciliation bill also, because Schumer had to be clear about what was going to be in the bipartisan bill before he was able to ask Bernie to fully decide on a top-line number for the reconciliation bill. And it's still undecided, even though Bernie was on television just a few months ago talking about a $3.5 trillion bill. That might still turn into a $4.1 trillion bill. But while on process, the Schumer gambit has been a spur to advance the Biden agenda. On substance, Portman Cinema has gotten worse with each passing day. First, there was the inevitable Republican pullout of the investment in IRS enforcement. That is to say, a political party that has dedicated itself to starving the IRS of revenue was highly unlikely to greenlight $40 billion for that agency. After all, if there's no money for enforcement, the tax laws won't be enforced, and that's what the Republicans want. The talk from the negotiations is that other pay-fors have been found, but that $100 billion hole was significant, and it's unclear what substituted for it, since the entire tax code now is off the table. There was some talk of reversing the Trump rebate rule for pharmaceutical products and plugging that into Portman Cinema. But Democrats want to use that for reconciliation. So there's a mad grab for the revenue raisers going on. How are we going to pay? How are we going to pay for this? How are we going to pay for this? How are we going to raise revenue? Of course, they don't have to raise revenue. They don't have to raise revenue. They just have to create the money, for crying out loud. But they don't want to do that. That would be to give the game away. Even though it's in the Constitution, nobody seems to understand that Congress can create money. It doesn't have to raise revenue unless it wants to. The good news is that this becomes another revenue piece Democrats can use in the reconciliation package. The bad news is that the Congressional Budget Office won't score increases in tax enforcement as raising revenue. While the parties could agree to a handshake deal under regular order, Democrats have less wiggle room to do so under reconciliation. They can add the IRS investment, but it would score as costing $40 billion. That's a circle they're going to have to square. Well, squaring of that circle is just ignore what the CBO says. The CBO is an advisory body to the Congress. I think the Republicans have often enough just ignored what CBO has to say. Anyway, meanwhile, transit funding has come up as another flashpoint. This is another case of Republicans just retrading the deal they already made. The original two-pager on Portman Cinema was very clear. There was $110 billion for roads and bridges and major projects, $66 billion for passenger and freight rail, and $48.5 billion for public transit. But Republicans apparently want to starve transit of the routine spending that's been folded into Portman Cinema, breaking the age-old 80-20 split between highways and public transportation. That split was already unconscionable, particularly if you believe this infrastructure package needs to address our climate needs. The talks have been tight-lipped, but that could mean less overall money in the bill now that the revenues from IRS enforcement are out, with all of it coming out of transit. As long as talks are allowed to continue, this trajectory is likely to persist as well. The Democratic moderates are apparently so focused on getting a deal that they're allowing the GOP to chip away at the substance, and even that hasn't guaranteed passage. The real open question is this: if Portman Cinema does fall apart and its elements are folded into the reconciliation package, will Democrats keep the most objectionable pieces that were added to gain Republican support? For instance, dozens of progressive groups are now on record on killing the privatization elements in the bill, with detailed reasoning about how private funding is more expensive, risks deficiencies in labor and maintenance, and eliminates democratic control. Would Democrats just port privatization over to reconciliation above this opposition? Question mark. There's a lot that isn't known about that reconciliation bill, and rumors are flying. The former director of the CDC under Obama, Tom Frieden, has suggested that funding for future pandemic preparedness has been cut back from $30 billion to $5 billion. If that has happened, wouldn't that be total insanity? Total insanity after losing 1 million people to this pandemic? You cut back pandemic preparedness from $30 billion to $5 billion? Who's got a screw loose somewhere in their heads? Other things are likely to be pushed back from Biden's initial plan, given the addition of Medicare expansion and other measures that did not appear in there. Meanwhile, the House is simmering about being locked out of policymaking. Even the best case scenario where the Senate gets a big bill across the line would involve no input on the part of the House. They'd have to accept whatever the Senate can pass. That usually leads to tensions. And finally, there's the little matter of the debt ceiling, which has been suspended for over a year. The suspension lifts next Saturday, and Senate Minority Leader Mitch McConnell has said his party won't lift a finger to pass it. He suggested that Democrats put it in the reconciliation bill. But there's no way that bill will be passed and on Biden's desk before the government runs out of borrowing room. This unthinkable, preventable disaster of failing to meet financial obligations already approved by Congress is something I've always seen as the spur to finally eliminating the filibuster once and for all. but not enough of the Senate Democratic Caucus thinks, but like me, says Dave. Well, to put another fine point on this, it seems to me what the Democrats ought to do is to say to Mitch, look, if you won't lift a finger to further extend the debt ceiling suspension, then we are going to put it in the reconciliation bill. But what we're going to put in the reconciliation bill is not an extension of the suspension. What we're going to put in the reconciliation bill is repeal of the debt ceiling altogether. We're going to get rid of it because we might as well be hung for a sheep as a lamb, and because we don't want any more debt ceiling baloney sausage from you, Mitch McConnell. Anyway, that's just one person's opinion, mine. Specifically, you want to play like that? We're going to play like this. See if you like this better. That's the only way you can treat Republicans. Okay, next topic. That's where the state of politics is with respect to the infrastructure bills, okay, at this point. But let's move on to something else, specifically voting rights problems. Visitors walked past the Supreme Court on June 26, 2021. Oh, you can't see this picture because I haven't shared the article yet. So let me fix that little problem so you can see what is going on. So this is a piece from Vox. How America Lost Its Commitment to the Right to Vote. This one is by Ian Millhiser on July 21st, 2021. And it's a very interesting analysis of what the Supreme Court has been doing with voting rights over quite a period of time right now. Supreme Court Justice Elena Kagan lamented in a dissenting opinion earlier this month that the court has treated no statute worse, quote unquote, than the Voting Rights Act. She's right. The Voting Rights Act is arguably the most successful civil rights law in American history. It was originally signed in 1965. It was the United States' first serious attempt since Reconstruction to build a multiracial democracy, and it worked. Just 2 years after President Johnson signed the Voting Rights Act into law, black voter registration in the Jim Crow stronghold of Mississippi skyrocketed from 6.7% to nearly 60%. And yet, in a trio of cases, Shelby County versus Holder, 2000, in Abbott versus Perez in 2018, and Brnovich versus the DNC in 2021, the court drained nearly all of the life out of this landmark statute. After Brnovich came a decision that inspired Kagan's statement that the court has treated the Voting Rights Act worse than any other federal law. It's unclear whether the Supreme Court would rule in favor of voting rights plaintiffs, even if a state legislature tried to outright rig an election. These cases are the culmination of more than half a century of efforts by conservatives who, after failing to convince elected lawmakers to weaken voting rights, turned to an unelected judiciary to enact a policy that would never have made it through the Congress. All of this is bad news for minority voters in America, who are most likely to be disadvantaged by many of the new restrictions currently being pushed in state houses across America, and for the country's by relatively young commitment to multiracial democracy. There are at least three reasons to fear that decisions like Shelby County and Brnovich foreshadow even more aggressive attacks on the right to vote. There's a picture of the front of the Supreme Court and the contemplation of justice statue outside the Supreme Court. The first is that Republican partisans can use race as a proxy to identify communities with large numbers of Democratic voters. In 2020, according to the Pew Research Center, 92% of non-Hispanic Black voters supported Democrat Joe Biden over Republican Donald Trump. That's after Trump slightly improved his performance among African Americans compared to 2016. This means that state lawmakers who wish to prevent Democrats from voting can do so through policies that make it harder for Black voters and, to a lesser extent, most other non-white voters to cast a ballot. And Republican lawmakers haven't been shy about doing so. As a federal appeals court wrote in 2016 about a North Carolina law that included many provisions that made it harder to vote, quote, the new provisions target African Americans with almost surgical precision. An even starker example, Georgia recently enacted a law that effectively enables the state Republican Party to disqualify voters and shut down polling precincts. If the state GOP wields this law to close down most of the polling places in the highly Democratic majority Black city of Atlanta, it's unclear that a Voting Rights Act that's been gravely wounded by 3 Supreme Court decisions remains vibrant enough to block them. The second reason to be concerned about decisions like Brnovich is that the Supreme Court's attack on the Voting Rights Act are not isolated. They're part of a greater web of decisions making it much harder for voting rights plaintiffs to prevail in court. These cases include decisions like Purcell versus Gonzalez, which in 2006, which announced that judges should be very reluctant to block unlawful state voting rules close to an election. Crawford versus Marion County Election Board, 2008, which permitted states to enact voting restrictions that target largely imaginary problems. And Rucho versus Common Cause, 2019, which forbade federal courts from hearing partisan gerrymandering lawsuits because the court's GOP-appointed majority deemed such cases too, quote, difficult to adjudicate, unquote. Just abdicated. We're not going to take these cases because they're too difficult to adjudicate. Finally, decisions like Shelby County and Brnovich are troubling because the court's reasoning in those opinions appears completely divorced from the actual text of the Constitution and from the text of federal laws such as the Voting Rights Act. Shelby County eliminated the Voting Rights Act's requirement that states with a history of racist election practices pre-clear any new voting rules with officials in Washington, D.C. It was rooted in what Chief Justice John Roberts described as, quote, the principle that all states enjoy equal sovereignty, unquote. A principle that is never mentioned once in the text of the Constitution. In Brnovich, the court upheld 2 Arizona laws that disenfranchise voters who vote in the wrong precinct and limit who can deliver an absentee ballot to a polling place. But Judge Alito purports to take a fresh look at the statutory text, quote unquote, in this case, but he imposes new limits on the Voting Rights Act, such as a strong presumption that voting restrictions that were in place in 1982 are lawful, or a similar presumption favoring state laws purporting to prevent voter fraud. These limits have no basis whatsoever in the law's text. As Kagan writes in dissent, Brnovich, quote, mostly inhabits a law-free zone, unquote. That doesn't necessarily mean that the Supreme Court will allow any restrictions on voting to stand. Under the most optimistic reading of cases like Brnovich, the court might still intervene if Georgia tries to close down most of the polling places in Atlanta. But it does mean that voting rights lawyers and their clients can no longer expect to win their cases simply because Congress passed a law protecting their right to vote. The rules in American elections are now what Roberts and his 5 even more conservative colleagues say they are, not what the Constitution or any act of Congress has to say about voting rights. How Republicans learn to stop worrying and oppose the Voting Rights Act. Yet, it was probably inevitable that the conservative backlash against voting rights would flourish in the one unelected branch of the federal government. When Congress first enacted the Voting Rights Act in 1965, its pre-clearance provision, the provision that was deactivated in Shelby County, was set to expire in 5 years. Congress extended pre-clearance 4 times, in 1970, 1975, 1982, and 2006, and each time the bill reauthorizing the fully operational Voting Rights Act was signed by a Republican president. At least some of these GOP presidents made aborted attempts to weaken the law. President Richard Nixon, for example, proposed allowing pre-clearance to expire in 1970, but he backed down in the face of intense opposition from civil rights organizations. Similarly, a significant faction within the Reagan administration, a faction that included future Chief Justice Roberts, pressed Ronald Reagan to veto a 1982 bill expanding the Voting Rights Act. In 1980, Reagan had denounced the Voting Rights Act as, quote, humiliating to the South, unquote. So this conservative faction appeared to have a sympathizer in the Oval Office. But Republicans in Congress and in the White House ultimately concluded that standing athwart the Voting Rights Act was too politically toxic. And then Representative Trent Lott, Republican of Mississippi, warned Reagan in 1981 after an expansive voting rights renewal had passed the House, quote, anyone who seeks to change, unquote, that bill, quote again, will risk being branded as racist, unquote. There's Reagan signing the extension on June 29th, 1982. At the time the Voting Rights Act was up for reauthorization again in 2006, the conservative opponents had largely given up on convincing elected officials to let much of the law die. The bill passed both houses by overwhelming margins and was signed by President George W. Bush. Quote, Republicans don't want to be branded as hostile to minorities, especially just months from an election. Anti-civil rights activist Edward Blum complained in a bitter 2006 article published by National Review. Blum would go on to be the driving force behind Shelby County and several other lawsuits seeking to diminish the rights of people of color. Yet, as it turned out, Blum understood something that the conservative opponents of voting rights who lobbied elected officials in vain did not. The premise of an independent judiciary is that judges must be insulated from political pressure so that they will apply the law without favor. This is why federal judges serve for life and why they're guaranteed to keep their salary as long as they remain in office. But those very same protections also allow judges who support an unpopular policy agenda to implement it without fear of losing their jobs. By the time Shelby County reached the Supreme Court, the court was dominated by conservatives who, in Justice Antonin Scalia's words, saw the Voting Rights Act as a, quote, perpetuation of racial entitlement, unquote. Quote, whenever society adopts racial entitlements, unquote, Scalia complained during the Shelby County oral arguments, quote again, it is very difficult to get out of them through the normal political processes, unquote. He then channeled the resentments of men like Blum. Quote, I don't think there is anything to be gained by any senator to vote against continuation of this act. Quote again, and I am fairly confident it will be reenacted in perpetuity unless a court can say it does not comport with the Constitution. So the court said just that. The Supreme Court's treatment of the Voting Rights Act has no apparent basis in the Constitution or the Act itself. One of the many frustrating things about the Shelby County opinion is that it doesn't even attempt to root its holding in the text of the Constitution. The question of what constraints the Constitution's text places on judges, especially when that text is ambiguous, is one of the most hotly contested questions in American law. But even when the court hands down constitutional decisions that are broadly criticized, it typically makes at least some effort to ground its holding in a specific provision of the Constitution. The court's anti-worker decision in Lochner versus New York and its pro-abortion rights decision in Roe v. Wade, 1973, for example, were both rooted in the 14th Amendment's promise, no one shall be denied liberty without, quote, due process of law, unquote. Indeed, even the court's decision in Griswold v. Connecticut, 1965, one of the most widely mocked Supreme Court majority opinions of the past century, at least tried to ground its holding in specific constitutional provisions. Griswold established married couples' right to use contraceptives and announced a right to privacy that formed the basis for subsequent liberal victories on abortion and sexuality. But the court swiftly abandoned Griswold's legal reasoning, which was rooted in the idea that the First, Third, Fourth, Fifth, and Ninth Amendments, quote, have penumbras formed by emanations from those guarantees that help give them life and substance, unquote. And yet, compared to Roberts' majority opinion in Shelby County, Griswold seems like a paean to textualism and judicial restraint. Shelby County never identifies which provision of the Constitution embodies the fundamental principle of equal sovereignty among the states that the court's decision rests upon. Although Shelby County does make a vague statement, the 15th Amendment is not designed to punish for the past. Its purpose is to ensure a better future, quote unquote. This principle appears nowhere in the text of that amendment. And in any event, the concept of equal sovereignty does not flow from Roberts' future-driven interpretations of that amendment. It can't even be found in the 15th Amendment's penumbras and emanations. We don't have to imagine what Shelby County might have said if the court had attempted to ground its decision in constitutional text and in nearly 200 years of precedent governing how courts should read that text. Chief Justice Earl Warren wrote that opinion for the court in South Carolina versus Katzenbach in 1966, the court's original decision upholding the Voting Rights Act. Which relies heavily on both the text of the 15th Amendment and a centuries-old line of cases holding that Congress's power to legislate should be construed broadly. The 15th Amendment has two provisions. The first prohibits the government from denying or abridging the right to vote, quote, on account of race, color, or previous condition of servitude, unquote. While the second clause declares that, quote, Congress shall have power to enforce this article by by legislation, unquote. Thus, as Warren explained, Earl Warren, this is, Congress has broad authority to enact laws preventing race discrimination in voting. Seems pretty straightforward, right? That's what the language says. Warren quoted a line of cases stretching back to the early days of the Republic. This is Chief Justice Warren again, which established that Congress's power to regulate is quite broad indeed. When the Constitution gives Congress the power to legislate on a particular subject matter, the court established in McCulloch v. Maryland, 1819, which was another case written by John Marshall, it may use, quote, all means which are appropriate and that are plainly adapted, quote unquote, to a legitimate end, so long as Congress does not violate some other provision of the Constitution in the process. Taken together, decisions by such as McCulloch and the 15th Amendment's text yield a clear result. Congress, not the court, gets to decide how it wants to fight race discrimination in voting. Congress, not a handful of Republican-appointed judges, gets to decide whether preclearance should exist and which states should be subject to it. Indeed, Congress would have the power to impose a preclearance regime on most state election rules, even if the 15th Amendment didn't exist. Although the Constitution's Elections Clause permits states to determine the, quote, times, places, and manner of holding elections for senators and representatives, unquote, it also permits Congress to, quote, make or alter such by regulations, except as to the places of choosing senators, unquote. Thus, the federal government doesn't just have nearly complete authority to regulate congressional elections. It explicitly has the power to displace state laws. And yet, as Franita Tolson, a law professor at the University of Southern California and a leading expert on the federal government's power to regulate elections, explained in recent testimony before Congress, Shelby County, quote, ignored that the Elections Clause stands as an additional source of authority, unquote, which quote, can justify federal anti-discrimination and voting rights and voting rights laws. It says actually legislation, but I was having trouble getting that out. So, stay connected from the NOS. That's an ad. So going on, the impact of Shelby County was fairly swift. In 2013, Texas enacted racially gerrymandered legislative maps, even though a federal court had rejected many key elements of these maps under the Voting Rights Act's pre-clearance provisions. Yet, with pre-clearance dead, the Supreme Court upheld nearly all of Texas's gerrymandered maps in Abbott versus Perez of 2018. Similarly, if preclearance was still in effect, it is unlikely that many of the controversial provisions of Georgia's recently enacted voter suppression law would survive. Certainly, no federal official acting in good faith would permit Georgia to simply start closing down polling places in black neighborhoods. Sam Alito's opinion in Brnovich pays no more heed to the text of the Voting Rights Act than Roberts' opinion in Shelby County paid to the Constitution. These people are from the Federalist Society that supposedly honors and treasures the original language of text of the Constitution. That case involved two interlocking provisions of the Voting Rights Act. One prohibits any law that results in a denial or abridgment of the right of any citizen of the United States to vote on account of race, or color. But notice any law that results in a denial. Doesn't have to be intended, doesn't have to be any intent there. It just has to result in a denial of abridgment of the right of any citizen. The other provides that the Voting Rights Act is violated if, quote, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by, unquote, voters of color, or such voters, quote again, have less opportunity than other members of the electorate to participate in the political process and to elect the representatives of their choice. That's a lot of thick legal language. But one searches it in vain for anything suggesting, as Alito wrote in Brnovich, that election practices that were common in 1982 are presumptively legal. Or as he also suggested in Brnovich, that state election rules are presumptively lawful so long as they supposedly combat voter fraud. As Rick Hasen, a law professor,
Jerry,
yes,
when did they start this thing with contraceptives?
Contraceptives were declared as legal. They were validated as legal in the Griswold case of 1965. So that case was a very, very important case,
Yeah.
as was stated here. As Sam Alito wrote in Kane Brnovich about election practices in 1982, they are presumptively legal, or as he also suggested in the same case, that state election rules are presumptively lawful so long as they supposedly combat the voter fraud. So you're searching the Constitution in vain or laws in vain for any justification of those two holdings by Alito. He just invented them out of thin air. As Rick Hasen, a law professor, um, 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 who's a law professor and election law expert at the University of California, okay, at Irvine, writes in Slate that Brnovich ignores, quote, the text of the statute, its comparative focus on lessened opportunity for minority voters, and the history that showed Congress intended to alter the status quo and give new protections to minority voters. Sam Alito's opinion in Brnovich bears the same resemblance to the text of the Voting Rights Act that Taco Bell does to Mexico. Just as significantly, Brnovich raises serious doubts about whether the Supreme Court would strike down any state election law that discriminates on the basis of race. Here's the case for a very limited amount, of optimism. One thing that surprised me after Brnovich was handed down is that my initial assessment of the opinion was slightly more optimistic than the view among many voting rights scholars, including Tolson and Hasen. I wrote that the Supreme Court left the Voting Rights Act alive in Brnovich, if only barely. Hasen, by contrast, accused Alito of essentially offering, quote, a new and impossible test for plaintiffs to meet, unquote, if they allege that they were denied the right to vote. Tolson told the legal podcast Strict Scrutiny that it's, quote, very difficult to determine what voting restrictions would violate, unquote, the standard laid out in Brnovich. So let me lay out the case for why Brnovich and the array of Roberts Court's decisions limited voting rights that preceded it may not produce an apocalyptic crisis for American democracy. This argument has three prongs. The first is that while Alito's opinion in Brnovich on the Voting Rights Act, it doesn't go quite as far as the Republican Party asked the court to go. The Arizona Republican Party's brief in Brnovich argued that, quote, race-neutral regulations of the where, when, and how of voting do not, quote, unquote, violate the act, which is a proposal that, as Kagan pointed out at oral argument, would allow a state to require all voters to cast their ballot at a country club. Meanwhile, Arizona Attorney General Brnovich suggested that voting restrictions that have a disproportionate impact on minority voters should be upheld, so long as the state didn't cause voters of color to behave differently than white voters. Thus, under Brnovich's standard, a state could potentially limit the franchise to country music fans because the state didn't cause white people to be more likely to listen to country music than voters of color. Republicans, in other words, gave the Supreme Court two different legal standards that it could have applied in Brnovich if the court wanted to effectively neutralize the Voting Rights Act altogether. The fact that the court rejected these proposed standards in an opinion that was otherwise completely shameless about its disregard for what the law actually says, suggests that some key members of the court may have balked at the GOP's request to shut down the Voting Rights Act altogether. The second reason for optimism is that while Republican state lawmakers have enacted a bevy of voting restrictions in the wake of decisions like Shelby County, most of those restrictions have not had as drastic an impact on voting as many advocates feared. Voter ID laws, for example, which require voters to show photo ID before they can cast a ballot, are a common voter restriction favored by many Republicans. Yet while initial research on voter ID suggested that these laws may disproportionately prevent left-leaning demographics from casting a ballot, more recent research suggests they have no impact whatsoever. They appear to neither diminish voter turnout, as Democrats feared, nor have any real impact on voter fraud, which Republicans often highlight to justify such laws, even though voter fraud is exceedingly rare, as we all know. Similarly, a recent paper by political scientists Maya Komisarchuk and Ariel White finds that Shelby County, quote, did not reduce aggregate Black or Hispanic vote registration or turnout. That turnout among these voters may have even slightly increased since the court's decision in 2013, an unexpected finding that the authors think may be attributable, at least in part, to voter turnout efforts, quote, explicitly targeted to counter potential voter suppression in the wake of the decision, unquote. I want to be cautious about being too optimistic here, as the court's decision in Perez suggests, even if eliminating preclearance did not diminish voter registration or turnout, it has made it easier for states to enact racial gerrymanders. And even if Democrats and voting rights advocates have thus far succeeded in countering Shelby County through counter-mobilization efforts, it's unclear if those efforts will remain successful forever. Shelby County is also less than a decade old, so it remains to be seen what impact more innovative voter suppression laws, such as the one recently enacted in Georgia, will have on turnout. But that brings us to the third reason to be cautiously optimistic. As Nicholas Stephanopoulos, a Harvard election law professor, wrote shortly after Brnovich came down, that decision does not preclude challenges to, quote, novel or unusual voting restrictions, because such restrictions, quote, were not prevalent in 1982, unquote. The more creative Republican lawmakers get in their efforts to restrict the vote, the more likely it is that the courts will balk. Two unanswered questions. The biggest threat facing American democracy is that state lawmakers may go beyond restrictions, such as voter ID, which make it harder for some voters to cast a ballot, and actually impose election rules that make it impossible for Democrats to win. Think of former President Donald Trump's failed attempts to pressure judges, state officials, and Congress into tossing out President Joe Biden's victory in the 2020 elections. Last year, the Supreme Court literally did the least that it could possibly do to preserve democracy in the United States by turning aside frivolous lawsuits brought by Republicans seeking to overturn Biden's victory. But future efforts to rig elections are likely to be more subtle, and the lawyers who defended those efforts are likely to be more competent than the band of misfits Trump assembled to challenge the 2020 election. We don't yet know how the court will approach those efforts. Consider, for example, Georgia's new law. The most troubling provision of that law permits by Republican officials to seize control of local election boards that have the power to close down polling locations and disqualify voters. This is a novel form of voter suppression. It's unlikely that many states permitted partisan officials to simply toss out Democratic ballots in 1982. So the court's decision in Brnovich should not prevent courts from intervening if Georgia Republicans go that far. But here's the rub, that Georgia Republicans start shutting down polling precincts in the largely Democratic majority Black city of Atlanta shortly before the 2022 election, or imagine that, say, Arizona passes a new law 1 month before the election that shuts down half the precincts in Democratic neighborhoods. The court's decision in Purcell held the justices should be reluctant to intervene in election-related disputes as election day grows close, because such decisions, quote, can themselves result in voter confusion and consequent incentive to remain away from the polls, unquote. Yet more recent decisions have treated Purcell less as a practical warning that judges should avoid decisions that might confuse voters and more like an inexorable rule that late-breaking voting rights decisions are not allowed. The danger, in other words, is that if the state imposes last-minute voting restrictions that seek to rig an election, the Supreme Court may forbid the federal judiciary from doing anything about it. Another unanswered question is how far this court is willing to go in giving Republicans an unfair advantage during the next redistricting cycle, which is expected to begin this fall. In a long line of cases stretching back more than a century, the Supreme Court has repeatedly rejected something known as the independent state legislature doctrine, unquote, which could potentially allow state legislatures to pass election laws that can neither be vetoed by a state governor nor reviewed by the state courts. But 4 members of the court recently endorsed this doctrine, and newly confirmed Justice Amy Coney Barrett's views on the doctrine are unknown. As Justice Neil Gorsuch summarized this doctrine in a 2020 opinion, the Constitution provides that state legislatures, not federal judges, not state judges, not state governors, not other state officials, bear primary responsibility for setting election rules, at least for federal elections. In its most extreme form, Gorsuch's approach could forbid Democratic governors from vetoing congressional gerrymanders passed by Republican legislatures. It could forbid states from using nonpartisan commissions to draw congressional maps, and it could even prevent state Supreme Courts from enforcing state constitutional safeguards against gerrymandering. The biggest uncertainty surrounding the court's voting rights decisions, in other words, is whether the court will enable efforts to lock Republicans into power, no matter what voters do to elect their candidates of choice, or the court's majority will at some point tell their fellow Republicans in state legislatures that they've gone too far. The answers to these questions, moreover, won't be found anywhere in the Constitution or in any law enacted by Congress. The Roberts Court's voting rights cases bear far more resemblance to the Old English common law. That is a web of entirely judge-created legal rules governing areas such as contracting and property rights than they do to the more modern, more democratic model where federal judges are supposed to root their decisions in legal texts. The future of democracy in the United States will be decided by 6 Republican-appointed justices' arbitrary whims. And if a majority of the justices do support a wholesale attack on liberal democracy, their actions will hardly be unprecedented. Nearly a century before President Johnson signed the Voting Rights Act, Congress and state legislatures passed a different kind of legislation that was supposed to guarantee the franchise to people of color. It's called the 15th Amendment, with its command that the, quote, the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, unquote. The Pre-Voting Rights Act by the United States did not deny rights to millions of African Americans because we lacked a legal guarantee protecting the vote. We did so because powerful officials, including judges, decided that they did not care what the Constitution had to say about voting rights. We're about to find out whether the Supreme Court is going to repeat that history. So have you got it? The Supreme Court is making decisions that are not rooted in legal texts or in the Constitution, not rooted in laws, not rooted in the Constitution, just making rules according to their own ideas, okay, of what is right. It's highly ironic because when these judges were confirmed, when they went before the Senate, they all claimed to be fundamentalists when it came to the words of the Constitution and textual interpretations of those words. They claimed that they thought the words of the Constitution were sacrosanct and that they would interpret the law according to the words of the Constitution. That is not what we're seeing here. We are seeing legislation from the Supreme Court, the making of laws by the Supreme Court, and the invalidation of constitutional rights as well as laws duly passed by the Congress of the United States. What are we going to do about it? Here's a piece from The Nation that suggests what we ought to be doing about it, and that criticizes Democrats for what they are not doing about it, for their approach to this problem, clearly outlined in that article. This piece was written by Elie Mystal, who's a columnist before The Nation. It's entitled, "The Democrats are bungling voting rights, but not in the way you think." This was done yesterday at 10 a.m. Maybe that actually means yesterday at 10 a.m. I don't know. It's undated other than that. Anyway, the John Lewis Voting Rights Act, still languishing in Congress a year after its name was changed to reflect the passing of the legendary civil rights activist, the Representative John Lewis, is a solution to a problem wholly invented by the Supreme Court. In 2013, Chief Justice John Roberts wrote the majority opinion in a case called Shelby County versus Holder, and in it he stripped away a key protection provided by the Voting Rights Act of 1965. Republican-controlled states used the opportunity Roberts gave them to further suppress the black vote, and his decision is a far bigger reason Donald Trump was able to run an openly white supremacist campaign and win the presidency in 2016 than any tales of economically aggrieved white people in Ohio that you may have heard about. The John Lewis Voting Rights Act is a good and sorely needed piece of legislation, as is H.R. 1 or the For the People Act, which addresses some of the voter suppression tactics employed by Republican states in the wake of Trump's defeat. But while the Democratic majority lacks the strength to pass this bill, Senator Joe Manchin, the apparent leader of the Vichy Democrats, believes that the Lewis Voting Rights Act is the best way to address the Jim Crow-style restrictions now favored by the Republican Party. He's even got one Republican, Senator Lisa Murkowski, to go along with him. No word on the other 9 it would take to pass the bill while still upholding the anti-democratic filibuster that Manchin claims is integral to, quote, democracy, unquote. Unfortunately, at this point, even if Congress somehow passes the Lewis Voting Rights Act, it will not be enough to stop Republicans' intent on suppressing the vote. Manchin, President Joe Biden, and congressional Democrats have somehow convinced themselves that the Lewis Voting Rights Act will succeed where the original Voting Rights Act failed and be upheld by the current conservative-controlled Supreme Court. They think it will be able to withstand the court's skepticism towards federal protection of voting rights expressed not only in Shelby County, but also in this month's decision in the Brnovich case in Arizona. The court's latest frontal attack on the rights of the minorities to vote. In a nod to the obvious conservative supermajority raised against voting rights, you will hear liberals say that the Lewis Voting Rights Act needs to be passed in a way that is, quote, constitutionally bulletproof, unquote. It is pleasing, no doubt, for elected officials and their constituents to believe that there is something that can be done by the legislature to overcome the voter suppression favored by Republicans. Democrats need to believe that there's something they can, quote, do, unquote. Democrats need their voters to believe that the party is doing what can be done. At this point, Democrats are basically Slim Charles from The Wire. Quote, if it's a lie, then we fight on that lie, but we gotta fight, unquote. But make no mistake, it is a lie. All of the comforting mouth noises in the world won't change the fact that the Supreme Court is controlled by conservative justices appointed by Republicans who are hostile to minority voting rights. There is no such thing as a federal voting rights law that is constitutionally bulletproof. The Supreme Court can strike down anything it wants, and the conservatives have made it clear they want to strike down the Voting Rights Act. Roberts has spent his entire career opposing the concept of minorities getting a fair chance at the ballot box, or anywhere else for that matter. Arguing against an expansion of the Voting Rights Act was basically Roberts' first real job in the Reagan administration. Clarence Thomas has likewise spent his entire career being the black guy who tells white men what they want to hear, that they've done enough and black people no longer need the protection provided by laws like the Voting Rights Act or the Civil Rights Act. These men will not be swayed by mere congressional action to protect voting rights. They do not believe Congress should have the power to defend minorities, and they've said as much. All one has to do is read what they actually wrote in Shelby County versus Holder. Liberals hoping to restore voting rights have pinned their hopes to a legal technicality embedded in Roberts' opinion in that case. Section 5 of the Voting Rights Act required certain states and counties with a history of racial discrimination to apply for federal, quote, preclearance, unquote, in order to change their voting laws. Shelby County, Alabama, for instance, couldn't reduce the number of polling places or forms of voter identification without first getting permission from the federal government. Preclearance was a fantastic way to stop segregationists from inventing new ways to disenfranchise black voters, but the scheme trampled over the power of states to control their own election. That's cool by me and by the Constitution's 15th Amendment. But I'm a guy who knows the 15th Amendment was necessary because of where, quote, states' rights arguments always eventually lead. Conservatives, on the other hand, are always eager to support the lost cause of states being able to discriminate against black people in whatever way seems best to them. In Shelby County, Roberts didn't declare preclearance unconstitutional. Instead, he ruled the formula used to determine which states and counties needed to subject themselves to preclearance contained in Section 4 of the Voting Rights was unconstitutional. Roberts said that by singling some states out for preclearance and not others, Section 4 violated the equality of states, which again, according to Millhiser, that provision, the equality of states, is nowhere in the Constitution. He then said that Congress was free to come up with some other formula and try again. The Democrats selling hope and rainbows have seized on this opening and would have us believe that modernizing the formula in some way that would apply to all 50 states, would appease Roberts and thus restore the protections of Section 5. That is at core what the Lewis Voting Rights Act attempts to do. The problem is that at best, the Lewis Voting Rights Act will just come up with a different formula for determining which states get singled out for special treatment. Any preclearance formula will result in some states having to ask permission to change their elections laws while others do not. And that is the big no-no according to Roberts. Yes, Roberts spent a lot of time arguing that the old Section 4 formula reauthorized in 2006 was too antiquated to be useful, which itself is Roberts substituting his personal opinion where a constitutional principle should be. But his core point is that states should not be treated differently from one another unless you can prove to Roberts' personal satisfaction that different treatment is functionally the only way to stop voter discrimination. There is simply no reason to believe that Roberts will think that even the freshest formula justifies disparate treatment of the states. The easiest way to get around Roberts' objection to unequal treatment of states is to essentially make all states subject to preclearance. That's not what the old Lewis Voting Rights Act was designed to do, but it's an option for whatever Bill Manchin seems to want. Everybody has to get preclearance. But that bill would be even more likely to fail in front of Roberts. Remember, the entire discussion of Section 4 coverage formula is just the Trojan horse Roberts is using to smuggle in his real argument that preclearance is a violation of states' rights. In Shelby County, Roberts calls the original Voting Rights Act extraordinary, quote unquote, 9 times. He does not use that implement. He means it literally. He thinks that the Voting Rights Act is something extra, quote unquote, that exists outside the, quote, ordinary, unquote, operation of laws. Instead of a bedrock achievement of decency over darkness, Roberts views the Voting Rights Act as an abnormal emergency fire hose of federal power that should be turned off as soon as the crosses cool off. You know, the crosses, Klan crosses. His entire opinion is written in the language of segregationists who object to the very notion that the federal government can step in and tell them what to do. A bill that essentially does away with Section 4's coverage or expands to the point where all states are subjected to Section 5's preclearance scheme would surely be viewed as a law of northern aggression by Roberts. Of course, not every conservative justice has time for the Roberts' roundabout defenses of Jim Crow. Clarence Thomas would make Section 5 unconstitutional outright. I'm not just guessing. Thomas wrote a concurrence in Shelby County where he put it plainly. Quote, I join the court's opinion in full, but write separately to explain that I would find Section 5 of the Voting Rights Act unconstitutional as well, unquote. Boom. If push comes to shove, I bet Roberts, along with Alito and Gorsuch, are much more likely to go with Thomas than they are to find some coverage formula they can live with. Thomas's concurrence is judge speak for mess around and find out, quote unquote. And here's the thing. Thanks to conservative manipulation of the Supreme Court and the stubborn refusal of liberals to retire at the opportune moment, the court today is even more conservative than the one that decided Shelby County in 2013. Even if the Lewis Voting Rights Act magically satisfied anti-voting careerist Roberts, there needs to be at least one other conservative justice who goes along for that ride. Who is that supposed to be? Perhaps alleged attempted rapist Brett Kavanaugh? Amy Coney Barrett, a person who, to get her job, danced a tarantella on the grave of the woman who wrote the dissent in Shelby County, unquote. I find it hard to believe the Federalist Society promoted people for the Supreme Court who disagree with Shelby County. Remember, all 6 of the conservative justices, including the alleged moderates Kavanaugh and Barrett, signed on to eviscerate another aspect of the Voting Rights Act, this time Section 2, way back at the beginning of this month. What are congressional Democrats and President Biden hoping for? A change of heart? Do they think if we clap very hard, voting rights will live? There is something the Democrats could do to restore the Voting Rights Act. Expand the Supreme Court. It's actually the only reasonable thing Democrats can do. The Supreme Court has made it clear there are not 5 votes to support the notion that non-whites should have equal access to the ballot box. If Democrats do not expand the court, then they accept that premise and leave black people their actual base of electoral support to fend for themselves against whatever ideas Republican governors can come up with to discourage them from voting. But to expand the court, you first need to break the filibuster. As we all know, Joe Manchin and Kyrsten Sinema, and probably Dianne Feinstein and Chris Coons, and 3 or 4 other spineless Democrats don't want to do that. Even if the filibuster is somehow defeated, it's pretty clear that Biden would want to use that power to pass an infrastructure bill as well as these well-intentioned voting rights protections that will be easily overturned by the Supreme Court in a few years' time. The will to do what is necessary to protect black people from Republicans simply doesn't exist in the current Democratic Party. So they feed us this lie, this falsehood that a carefully tailored voting rights the restoration bill will be above constitutional reproach, even though conservatives on the Supreme Court have literally already told us precisely how they will strike down any new voter protection bill should they have to. Democrats are trying to wish a better Supreme Court into existence because they don't have the political strength to use their constitutional powers to make one. I know this isn't what most liberals want to hear, but it is the truth. Bills promising federal oversight of state elections are dead on arrival at the conservative Supreme Court. The only way to fix that problem is to fix that court. Everything else is a pointless show, a cacophony of sound meant to distract people from the cold reality that democracy is sinking. Now, I think that's a brilliant article. I generally agree with the argument all through it. I think when you add the Millhiser article to this article, you really come up with a desperate situation with respect to this particular Supreme Court. So what is there to be done? Well, first, of course, you do need to pass the Voting Rights Act, some version of the Voting Rights Act. And remember, there are now 3. There's the John Lewis Voting Rights Act, there's the For the People Act, and the more recent act, in order to prevent the legislatures from simply throwing the votes out, of people whose skin color they don't like. That was the Amy Klobuchar bill that she introduced, a couple of weeks ago. So all those 3 bills have to be passed, or a single bill putting the key provisions of all of those in have to be passed. How do you fight the Supreme Court and the argument that's made by Mistal here? I've told you how, on numerous occasions. What you do is you include in the bills you pass the exceptions clause of Article 3, Section 2 of the Constitution. Here is the text. Cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In other words, the cases can be brought directly to the Supreme Court. But here's the next sentence, which is key. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such by regulations as the Congress shall make. The key phrase is that the court shall have appellate jurisdiction, that it shall be able to operate as an appeals court, both as to law and fact, but only with such exceptions and under such by regulations as the Congress shall make. So the Congress can say, with respect to a particular law, the Congress can say, the Supreme Court shall not have jurisdiction over this particular law. To be more clear about that, it takes away their power. That use of that exceptions clause takes away the power of the Supreme Court to review new campaign finance reform legislation or new legislation with regard to voting rights, or more generally, legislation excluding money from politics. The Supreme Court can be denied the authority to take up any cases involving a review of legislation, in connection with them. In other words, the appellate courts of the United States can be denied jurisdiction over cases involving specific legislation passed by Congress, so that they cannot take up such cases, much less perform judicial review of legislation in connection with them, which means they can't declare them unconstitutional because they can't even review them, because Congress prohibits it using this exception clause. If Congress uses this exception clause in connection with the new Voting Rights Act that's passed by Congress, and it would take using the nuclear option, getting rid of the filibuster, Sinema and Manchin and the others would have to get rid of the filibuster, at least with respect to that class of legislation they are trying to pass. If they used that and they passed the necessary voting rights legislation, that would give the rest of us time to follow Misthal's recommendation and to pack the court. So there was no longer a 6-3 conservative advantage on the Supreme Court. Is that bad? Is that bad? Look, This Supreme Court is making decisions without reference to the text of laws, without reference to the text of the Constitution, in clear violation of the 15th Amendment to the Constitution. That is what it is doing. Is it unfair or reprehensible for the Congress to discipline to the Supreme Court by saying to it, look, if you're going to do that, if you're going to ignore amendments to the Constitution, if you're going to ignore our previous law and not even quote the text and declaring it unconstitutional, then we're denying you the jurisdiction to do that under the authority granted us in Article 3, Section 2 of the original Constitution. This is not even the 14th Amendment thing. This is not even any of the first 10 amendments or 12 amendments. This is the original Constitution. Article 3, Section 2 gives us the authority to do that to you. And we are hereby doing that right now because of the way you've acted, because of your behavior in making decisions that have nothing to do with the written text of laws or the written text of the Constitution. Not even a fig leaf presented to try to reason from those particular texts. You are not old English justices making arbitrary laws. You are American justices sworn to uphold the Constitution, including the 15th Amendment. And you have not been acting in that way. So, you will not have jurisdiction over these various laws. And if you proceed to act up anymore, we're telling you something else informally. We will strip other laws from your jurisdiction as well. And we will keep doing it until you decide to base your decisions based on law. And by the way, while we're doing that, we're going to pack your court. So it doesn't really matter what you Federalist Society justices decide any longer. You're just going to be in a minority because we're appointing 6 more justices and we're confirming 6 more justices. And we are neutering your lawless behavior on this Supreme Court. It gives us time to pack the court, and it gives us time to pass a constitutional amendment stripping artificial persons, such as corporations, of the rights afforded to biological individuals, such as ourselves. That's what this is about, people. That's what this is ultimately about. We need the time to pass that amendment. We can't have the corporations controlling our politics through the 6 or 7 years it would take to pass an amendment. So the amendment cure is impractical right now. The pack the court cure is probably impractical right now. But passing voting rights legislation with an exceptions clause in it may not be impractical. It takes enough pressure on Joe Manchin and Kyrsten Sinema, and the others to at least allow an exception to the filibuster to use the nuclear option with in the case of a particular class of cases. Then you pass that law, include the exceptions clause in it, then you have the time to work on packing the court, and you have the time to work on and pass a constitutional amendment bringing corporations down to their previous state of subordination to the rest of us. These things must be done. Okay, that's my pitch for tonight. Hope you like that pitch. I will go back to the beginning and check out your comments. And Barney says, hi, everyone. Kay says, hi, Steve. Steve Holmes says, is Howard still going to come on? Doesn't appear so. No, Howie is coming on Saturday. He wasn't able to make it because he had a previous engagement, today. He has confirmed that he's willing to come on, on Saturday. And we are going to be spending then Saturday, generally speaking, we will be going over Howie's version of the Green New Deal because it may be the best version out there, and we want to discuss it in great detail. So that's what's happening on Saturday night. Okay, I may be a little tired on Saturday night because I'm not actually planning, on marching. I don't think it will necessarily be good for me to march where the temperature is 85, or 86, and to do a long walk, at my age, in that. But I am currently planning to go down there to hear the speeches and express my solidarity. So I'll be getting back then probably fairly late. I probably won't be back here until 6 o'clock or so because it takes a little while to get back here. I'm a little far out. But that should be plenty of time to be ready by 9 to do my live stream. So Kay says, Bernie was on several times today too. He still wasn't sure. And Dolores says, Howie will be on Saturday. Yes, of course, if the creeks don't rise, if no illness intervenes, as was the case with Indy left today. Steve says, okay, thanks, Dolores. Steve says, asks, not sure of what. Steve says, support the strikers, boycott the Frito-Lay products. That's great. We have to support the strikers and boycott their products, the Frito-Lay products. But what we really have to do is get these corporations to obey the law. And we need reform. We need reform of the labor leaders at the federal level so that the rights of workers are not enforced by a commission that acts rather slowly and rather deliberately. We need the law to be changed such that when corporations violate labor laws, the Attorney General of the United States can haul them into court, prosecute them, and send them to jail. No fooling around with workers' rights anymore. The authority of the Secretary of Labor, he's just too toothless. It's too toothless. The New Deal reforms were too toothless. The corporations of today will violate them left and right and consider it just a cost, of doing business. The only way to stop that is to make these violations criminal offenses, prosecute them, send them to jail. Kay says, the ending amount of money, Steve Wolfbrand. Steve Wolfbrand says, oh, okay. Ghost Star says, "What's up?" Hey, Ghost Star, you having another party tonight? Lana says, Lindsey Graham said he would, that he'd be willing to negotiate the debt ceiling if the Social Security Trust Fund was up for negotiation. Well, I have a good idea for him. I have a great idea for him and for us. Okay, my idea is that we kill the trust fund, pay for Social Security out of general revenue, okay, again, and fix it so that it's always past a year ahead. So that there's always time to mobilize people across the country to destroy any politician that refuses to vote against the Social Security appropriation. But for the following year. Then we aren't going to need the Social Security Trust Fund. And by the way, we should couple that with the president having the $100 trillion coin minted so that there's $100 trillion in the Treasury spending account, so there's never an excuse to cut Social Security payments ever again. Steve Wolfbrand said, did we ever really have a commitment for fair election or voting rights? There was a commitment, I think, to work towards that. What Millhiser is talking about is he's saying at one time there was a legal consensus, and this legal consensus included Democrats and Republicans to work for elections to try to make them more and more fair as time actually went on. That's why so many Republican presidents voted to extend Section 5 of the Voting Rights Act of 1965, because there was such a bipartisan commitment. And there was certainly a commitment among lawyers for a very long time. What the Federalist Society and John Roberts and his cohorts have done is that over a period of years, they've destroyed this particular commitment. It was what they set out to do, because I believe a number of them are racists, and they were successful in doing it. If anyone is new here, Dr. Joe reads the comments at the end. Feel free to ask questions. Kay says, not any time lately that I can remember, Steve Wolfbrand. And Steve says, with justice and liberty for all. Yeah, right. Laugh out loud. It's with liberty and justice for all, Steve. But yes, laugh out loud. Ghoststar says, Tokyo has hit another 6-month high in new COVID-19 cases one day before the Olympics begin. Thursday's 1,979 new cases are the highest since 2044 was recorded on January 15th. So the Olympics is certainly likely to be a super spreader event. Gorstadt says, Israel now says the Pfizer vaccine is down to only 30%, only 30% protection against COVID infection, okay, in the last month. But Ghost Star, if you have a link to that, I would certainly like to see it, because last I heard, I thought that Pfizer said that its vaccine was effective 88% of the time, even against the Delta variant. So that seems to be conflicting information. Kay says, check out Jim Jordan's district in Ohio sometime. Shake my head. Steve Wilbert said, I mean, you probably should take your ID when you go to vote, right? Just saying. Kay says, easy vote by mail was one of the few things I liked about Arizona. Now they have ruined that too. CoStat says the U.S. Senate votes to add $25 billion to the $743 billion defense budget. Oh, these people, they're just... Well, the way they play politics is freaking idiocy. Kay says, have to go get x-rays and examine a dentist tomorrow. Kind of stressed out about that. I've been avoiding dentists for years because I figure, well, whatever they decide I need, I can't afford it anyway. Patrick's Time says Biden did terrible last night. He says this, okay, on YouTube. Patrick's Time says the median age of COVID death in USA is 78. The median life expectancy is 76. I don't think it's gone down to 76 yet. I saw that statistic somewhere today. It has fallen by a year, actually a little more than a year, as a result, okay, of COVID. Yes, it has, but I don't think it's fallen as low as 76 yet. And Lana says, at Patrick's, I only saw the Rational National. Take on it seemed like a mixed bag. Well, not with respect to life expectancy, it wasn't a mixed bag. There was supposedly a decline of over a year between what it is now and what it was before COVID. Patrick's Time says, why are Democrats bringing back by Jim Crow? Well, I don't think the Democrats are bringing back Jim Crow. I just don't think they're fighting hard enough. Patrick's Time says Democrats should pay reparations. Well, I don't think the Democrats should pay reparations. I think that reparations should be paid by the government of the United States. Yes, there should be reparations. Kay says, I hate sick care. Patrick's Time says, expanding the court, okay, is not reasonable. Well, what the court has been doing is not reasonable. As I just got through saying, as I just got through showing, the court is making decisions without any basis in written texts. That is illegitimate. It's not what it is supposed to do. The Supreme Court is not supposed to be an arbitrary body. The power of judicial review is not even written into the Constitution. But even if it were written into the Constitution, the power to deny judicial review to the court is in the hands of Congress. Steve Wolfbrand says, you'll feel better when it's over. By the way, Lee Camp has a fund to help people, or you could do a GoFundMe. I don't know, do you really think GoFundMes work? They work for some people. I don't think they work for others, or generally. The exam will be free, but after that, I'm not sure. Patrick's Time says, the liberals now fight for the establishment. Well, I'm not sure what you mean by liberals, because that term is thrown around now all the time. I don't think anybody knows what a liberal is. Supposedly, the establishment are the liberals, but I just think it's such a vague term. Everybody now uses the term with a negative connotation. Ghost Start says the Democrats have total control. They just refuse to use it. Ghost Start. Which Democrats have total control? Our political parties do not have iron control over the representatives in Congress that organize with them. It is not that kind of system. Yes, Democrats technically have total control. They have control necessary so they get the chairmanships. So they get to have control over the schedule. But, as you well know, all the Democrats do not agree on what to do. 42 out of 50 is more than 80% of the Democrats who would be willing to do away with the filibuster and pass the Voting Rights Act. There are others who would probably do away with the filibuster if Joe Biden asked them to do it. One of the big problems is Joe Biden himself appears to be opposed to getting rid of the filibuster. But at least he has to come out on the side of getting exceptions to the filibuster in the area, of voting rights. And if he has any sense, he's going to use the exceptions clause of Article 3, Section 2. Patrick's Time says, who doesn't have a right to vote? There is no right to vote that is written into the Constitution of the United States. Of course, the Civil War amendments say, especially Amendment 15, that blacks have, people of color have certain voting rights. But there's no general statement of a right to vote in the Constitution of the United States. So the various states can put various obstacles preventing people from exercising their right, to vote, making it much more difficult and making it much more easy for other people to exercise the right to vote. That was going on wholesale in 2020. There were more than enough polling places for people in the rural areas. No lines for them. Easy to get in, easy to get out. And in the big cities, certain states were removing voting places. They were removing drop boxes. In Harris County in Texas, where Houston is, it's a huge county. The state of Texas was doing whatever it could to make it really difficult for people to vote. I don't know how many points were denied to Biden in Texas. How many votes by those practices? But it was there. It was a big factor in the election in Texas, in the elections for Congress and for the presidency. Kay says, even Medicaid expansion is so screwed up in Ohio. Lana says, liberals are the establishment. Patrick's Time says, yep. Lana says, lots of people are supposed to have the right to vote, but suppressed, prevented, dissuaded from doing so. Patrick's Time says, status quo. Patrick's Time says, voting must be more secure than easy. Well, I simply disagree. It must be easier. It doesn't need to be made any more secure. There's no indication. Now, certain aspects of it have to be made more secure, like the counting, and the tabulation, and the voting machines themselves. They should either be made more secure or they should be gotten rid of, and we go back to paper ballots. By requiring ID is common sense. But that is not what they're doing, Patrick's time. They're discriminating with respect to IDs. Certain IDs, okay, are legitimate, okay, according to them. For example, okay, if you have your permit to carry a gun, if you have your gun license, that's fine for Texas. Okay, but if you have a college ID, that is not accepted, okay, in Texas. There is blatant discrimination with respect to type of ID all over the country to advantage certain prospective voters and disadvantage others. Lana says if ID is requested, it should be provided by the government who requires it. There are some people who don't have the ID the state calls for. They have some IDs, they don't have other IDs. This may be a relatively small minority of people, but on national scale, it can amount to millions of votes. Now it says voter fraud, okay, is minuscule, or no impact election results. Voter suppression, okay, and election fraud are way, way more of a problem. Absolutely. Joe, what is your take on the probability of H.R. 1 being signed into law? Do you think it will happen? Okay, it's not a question of probability because there's nothing random about it, Russ. Okay, so the question is, but what is my take on the likelihood of H.R. 1 being signed into law? To answer that question, okay, I cannot say. Okay, it really depends on whether a few people can be convinced, okay, to at least allow an exception to the filibuster in the voting rights category, okay, of law. Such an exception can be made. It could be executed actually in the Senate through use of the nuclear option. It is feasible for them to do it. I think Biden can persuade everybody else to come aboard. Then it will be up to Sinema, okay, and to Joe Manchin. And I just don't know what they're going to do. I think pressure is increasing on Sinema, okay, in Arizona. The polls are showing that she's been taking a big hit. If the Democrats cannot get these voting rights acts passed, and if they continue to struggle with infrastructure bills and things like that, and they're being blocked by the filibuster, then it's likely Sinema will be defeated for re-election, and the polls are beginning to show it. So she may decide that she can't afford to keep on going that way, Russ. Oh, but by the way, Russ, I'm glad you're here. But welcome back. So, I don't know. Is it 50-50? I don't know. I can't assess that. I really can't assess that. Okay. I think in the end, Joe Manchin is likely to reason that this is a party question and that he is a member of the Democratic Party. After all, he does have some regard for what Labor thinks of him. He's going to care whether the PRO Act actually gets passed, okay, or not. He's going to care whether the Voting Rights Act happened, because, by the way, he could find himself with the rest of the state controlled by Republicans. He could find the state legislature in West Virginia actually rigging votes against him. H.R. 1, the John Lewis Voting Rights Act, the Amy Klobuchar Act, the prevention of that third act. I don't know why I keep on forgetting the name of that act, but I will look it up again. Those three acts will protect Joe Manchin from having his own ox gored. Now, there are people who say he doesn't really like the Senate. He'd like to go back to West Virginia, and he'd like to be governor of that state. If the Republicans engage in wholesale voter suppression of poor people in that state and people of color in that state, he would suffer at the polls. He might not be able to go back and become governor. If he wants to continue in the Senate, he may find that he's a dead pigeon too, like so many Democrats across the country. Okay, so in the end, he can pay a political price if those bills do not pass. And it is within his capability and the other senators to run a nuclear option on that particular category of voting so that a 51-50 voting situation can be created. And that's what they need to get that vote passed. If Biden signs it, it becomes the law of the land. If they put the exceptions clause in it, the Supreme Court won't be able to do anything about it. It's there. Patrick's Times says the Democrats are so racist. They believe that black people are too stupid to have a valid ID. Some Democrats, maybe, but nowhere near as many Democrats as Republicans. Bellata says, define what that ID should be, then make sure people have it. Simple. Patrick Times says election fraud is real. Just look at 2020. I am looking, at 2020. I don't see evidence that it's real. What's your evidence that it's real? Patrick's Times says, no chance Biden got millions, by millions more votes, than Obama. No, there's plenty of chance. And the reason why there's plenty of chance is because Obama ran in 2008 and 2012. And Biden ran in 2020. And there were many more voters around in 2020 because the population of the United States had increased. Don't merely look at the total of Biden's votes. Look at the margin of victory for Biden compared to the margin of victory for Obama. Obama's margin of victory was much larger than Biden's. With the size of the electorate in 2020, if Biden had had a margin of 53 to 47%, as Obama had in 2008, then it would have been totally a runaway for Biden. It wouldn't have been 306 to, it was 306 to 232 or something like that, whatever it was. It wouldn't have been like that. It would have been much, much larger. It would have been 380 electoral votes, probably approaching 400 electoral votes. And Lana says, laugh out loud, Patrick's. People wanted Trump out. Patrick says Trump won. Lana says, troll alert, troll alert. is like, Biden is your guy, own it. No, Biden is not our guy. No, Biden is not our guy. Sanders was our guy, not Biden. We voted against Trump. We didn't vote for Biden. And we voted against Trump because Trump was fixing to be a dictator and a fascist dictator to boot. We recognize that. And that's why we got rid of him. Patrick's Time says Biden and Harris will bring another 4 years of Trump. Very possible. Very possible. They are not doing well now. Carmen says, yeah, Trump won at killing thousands with his COVID hoax of their election and genocide. Trump, with his incompetent management of COVID, has killed nearly 1 million Americans now. It wasn't thousands. It was nearly 1 million Americans whose deaths could have been avoided. How do we know? Look at Australia. Look at New Zealand and their fatality rates. If we had fatality rates such as those, 99% of the people who died, 99% would have been saved. That's how bad Trump was. Carmen says, establishment politicians and neoliberals, the enemy of the public. They are. Patrick's Time says Biden is the most establishment president in history. I wouldn't say that, but he's certainly an establishment president. One of a long line of presidents, who were establishment, including George W. Bush, George Bush, and Reagan. They were all establishment. Steve says, but you might have a chance with Medicaid, but Medicare doesn't cover it. Carmen says, we're no fans of Biden. We're fans of policy. Kay says, not up here, Steve. Balada says, I meant the Rational Nationals' take on Biden and the CNN town hall, a mixed bag. I haven't seen that yet. Carmen says, liberals was originally a negative term. Yes, during the 19th century liberals, yes, it was a negative term. Actually, before that, it was a positive term. In the French Revolution, it was a positive term. After the 19th century, it once again became a positive term. The brand of liberalism that was favored by Franklin Roosevelt and other people at that time was a positive term. Patrick's Time says that the liberals today aren't liberal. Yes, they aren't liberal, not in the way that FDR was liberal. And Steve Wolfman says, full moon rising here, not even dark yet. We need the Dolores to interpret. So tell me, Steve, is it a pale moon rising? Steve Wolfbrand says, states' right to control their own elections sounds like a leftover from slavery. It is a leftover from slavery. That's what John Roberts is. He's a leftover from slavery. Gostot says, down to 39% effectiveness according to Israel's Ministry of Health since June before the surge, so probably even lower now. Carmen says, every day it's something different, Gostot. And Carmen says, well said, Joe. I'm not sure what you think I said well, Carmen, but thank you anyway. Patrick's Time says, CHL, the license is a state ID. I don't know what a CHL license is. Patrick's Time says to get a college ID, but you must have a valid ID. Well, I don't know which state you're talking about, but this varies from state to state. But I don't see why college IDs cannot be valid IDs. It all depends on whether they're hardened or not, so they cannot easily be forged. Oh, okay. CHL is a concealed handgun license, a state issue. Of course, it's valid, okay, for voting. In Texas, it's valid for voting. In certain other states, it may not be valid for voting. Those requirements, ID requirements, should be standard across the whole country. They should not vary from state to state, because if they vary from state to state, then the right to vote varies from state to state.
Virginia has a voter ID card.
Yeah. We have a voter ID card here too. I have to say, I don't think that voter ID card is very hard. It seems to me it would be quite easy to forge. However, I don't think there's much forging of voter ID cards going on here. I think that things seem to be pretty clean in this state. When it comes to, people allowing voting, it seems like in this state that people are still pretty goo-goo when it comes to voting, to use a Republican term. People here kind of believe in the clean government when it comes to voting. Now, there are other areas where they play pretty rough. So when it comes to voting, they seem to be pretty relaxed here. And Patrick says college IDs could be forged easily. Well, the colleges, I'm sure, could create IDs that would not be forged easily. It all depends on whether the IDs would be accepted as valid IDs for the state. Patrick says, but your arguments hold no water. Well, that's fine, Patrick, because I think your arguments are ridiculous. So that's all right. You're entitled to your opinion. Carmen says, a big important factory had to shut down in West Virginia. Folks are saying Manchin is totally absent on the subject. Yes, he has been totally absent on the subject. Kay says West Virginia is very corrupt. Yes.
But this, you had to prove
Yeah, this was, yeah.
so much so you could get on a plane.
Yes, right, but that's not the voter ID
No,
card.
it's not. That's not. Voter
It's the, yeah, that's the actual federal ID, right?
Mm-hmm.
Yeah. Okay, so we have a voter ID here in Virginia. Well, it's not a voter ID, but we have an ID card here in Virginia that is very hard and is hard to forge. And we had to do something special to get it, okay, about a year ago. Okay, and it's valid for boarding planes, which is why we had to get it.
It's not going anywhere.
Yeah, now we're not going anywhere because of COVID and stuff like that. And cases West Virginia is very corrupt. Yes, I know the party is very corrupt, okay, in West Virginia. And Carmen says, I think it was in Morgantown. Does that sound familiar? Yes. Ghostot says, chaos theory on steroids, incremental death. Kay says, thank you all for another great discussion. We love you all. And we love you, Kay. Lana says, wasn't it Texas that refused to honor the VA status for voting? Could have been. I don't know. Texas is really strange. Lana says, agreed. There should be a federal ID provided by the federal government. This isn't that difficult. It isn't that difficult, right? I completely agree. Oh, here we go. We have Chaos Sang here, but he's adopted a new name. I'm sure it's Chaos Sang because nobody could be so ridiculous. He says, North Korea is one of the greatest states in the world. They do MMT. They are the last communist state in existence, the last democracy, says the Falcone general. Falcone general. What is a Falcone general? And Ghost Art says, breaking, shooting. But multiple people shot on 14th Street in Washington, D.C. Was that, when you say 14th Street, okay, is it northwest or southeast or what? Or southwest or northeast? Okay, it makes a difference. There is no unambiguous 14th Street in Washington, D.C., but it sounds like it's northwest, maybe. Maybe Midtown. Anyway, Miami Herald reports DeSantis schools, feds will not mandate masks. If they do, he will have legislation ban them. By Ellen class, the killing continues. Shake my head. The Falcone general says, I'm not chaos. I used to do the International Workers Movement podcast on KRTD. Okay, Falcone general. And DeSantis on school says, but correction. Okay, folks, I think that's the end. It's over. It's time for me to say goodnight. I will see you on Saturday, as of now, with Howie Hawkins. Saturday at 9. We're going to go in depth to the Green New Deal. KRTD Media says, yes, the key word is used to. Oh, thank you, Shane. And Laura says, thank you, okay, and good night all. I'll probably have some news about the march also by then, hopefully, if all goes well and the creeks don't rise. Russ says, enjoy your Friday, Dr. Joe. Thank you, Russ, and thank you for coming. It's really good to see you again. Okay, friends, I'll see you on Saturday.